Welcome, and thank you all for being here today. My name is Jake Charles, and I'm the Executive Director of the Center for Firearms Law here at Duke Law School. We are really glad to be able to host this important discussion on race, policing, and guns. Even a casual glance at the evening news reminds us of the intersection among violence, both public and private, racism, and the ubiquity of firearms in the United States. The ongoing national conversations around race and policing in America are grappling anew with the role of guns in these systems and institutions. We're fortunate to be joined today by several distinguished experts to help us unpack these issues in a conversation this afternoon. Before introducing the panelists, let me say a few words about the format for today. For the first 30 to 45 minutes, I'll be asking the panelists questions, and then at the end, we'll have a time for a moderated Q&A. So please, if you do have any questions that come up in the panelist discussion or in the first part of the conversation, pop those questions into the Q&A box at the bottom there. You can ask those questions at any time. You don't have to wait till the end to ask them. You can ask them anonymously if you want to remain anonymous. You can ask a question to a particular panelist, or you can ask a question for the panel as a whole. We'll take as many of those as we have time for at the end. I also want to thank the Duke Law American Constitution Society and Duke Law Federalist Society for co-sponsoring today's event. And just one more note is that today's discussion is being recorded. Okay, let me introduce the panelists for today. I will be asking them questions in the order I go through here. First, we have our very own Professor Daryl Miller. He's the Melvin G. Sim Professor of Law, Associate Dean for Intellectual Life, and Faculty Co-Director of the Center for Firearms Law. Next, we have Cami Chavis, Associate Provost for Academic Initiatives, Professor of Law and Director of Criminal Justice Program at the Wake Forest University School of Law. Next, we have Stuart Schrader, Lecturer and Assistant Research Scientist in Sociology at Johns Hopkins University, and Alice Ristroff, Professor of Law at the Brooklyn Law School. Thanks to all of you for joining us today. My first question is to you, Professor Miller. You've written recently about how calls to defund the police may end up being more harmful to the safety of Black Americans, at least if those calls are successful. Can you say a little bit about what led you to that conclusion, and maybe what guns have to do with that calculus?
Sure. Thanks for the question, and thanks to all of you for participating and to our guests as well as sponsors for this event. So I think the issue here about how guns are related to this and the sort of defund the police is, as we've seen in places like Kenosha and others, that the desire for policing might in fact be somewhat insensitive to the fact that you have different sort of groups in a particular area. So I think one of the issues here is like, if you end up defunding the police, or in the most radical sense of abolishing the police, that is going to encourage individuals who are empowered by many jurisdictions that have fairly robust gun rights to do the policing on their own, either at the invitation of some individuals within the communities or on their own initiative. The hypothetical that I give is something like Atlanta. So, you know, Atlanta had some protests about policing there. But if you ended up abolishing the Atlanta Police Department, that doesn't necessarily mean that, for example, predominantly white individuals wouldn't come into the city empowered by state law to carry their own guns and act as a self-proclaimed security detail for businesses or others within the community, and that can be incredibly racially inflected. And that's what I worry about with the idea that defund the police means abolish the police in an environment in which there are already a lot of guns and gun rights as a baseline level.
So let me then, continuing on that theme, turn to you, Professor Chavis, and ask you, your scholarship focuses, at least in part, on criminal justice reform and police accountability. What are some of the politically feasible ways that you think reformers should be working to address police violence, especially in what seem to be the increasing episodes of killing of Black Americans?
Yes, hi. Thank you. Thank you very much for having me. I think that, first of all, a couple of important points. We've seen just horrific instances of police violence lately, but for many Americans, particularly Black Americans, these scenes are nothing new. What's new is just the ubiquitous nature of, we have police body-worn cameras now. We have lots of cell phone bystander footage. So the activities of the police actually are becoming much more transparent. And it's difficult for a lot of times when in the past, when we would see these instances, we were able to have kind of a he said, she said with the officer receiving a lot of deference, right, for what happened in a situation. So I think when I think of terms of what's politically feasible, another thing that we have to take into account is the idea that that it's not, and you hear this, I hate to even say this, the bad apple analogy, because that's so old and worn out, the terminology, but what we mean by that is that we have to look at law enforcement culture instead of individuals, and we need to think about law enforcement culture promotes or tolerates or encourages certain behaviors in police officers. So if we take those two things, that we need more transparency around what's actually happening, and we need to address the culture, there are a lot of different ways that we can address the culture, and I could talk more about some of those ways as we go along. But I can't overemphasize the need to be more transparent, and we need to keep better records. We need to have national databases that help us understand what's happening in different parts of the country, so we can evaluate what practices are working. But of course, we need to take a look at our use of force standards and what is appropriate or not. It is unfortunate that we have certain instances of, whether someone's selling loose cigarettes in the case of Eric Garner, or in the case of George Floyd, some allegation of counterfeit, and you have armed first responders coming to these instances. And so we really have to take a look at that and at the substantive criminal law that allows those types of interactions to happen. So in your question is that it's not a simple fix, and there are lots of different ways that we can address it.
Great, thanks so much. And turning to you, Professor Schrader, maybe stepping back and thinking about how we got to, at least part of the story of how we got here. So in your book, Badges Without Borders, you chronicle the ways that the American police forces have become militarized over the last 60 or so years. And you note an emphasis on racial control in policing. Can you talk about the roots of that militarization and maybe what it has looked like, especially with regards to domestic police firepower?
Sure, thanks. I would argue that the militarization of policing has been occurring since the outset of the 20th century, precisely through the blurring of colonial racialized social control and domestic racialized social control. Many of the most prominent police reformers and experts in the 20th century had military backgrounds, had experience in wartime, and often made reference to war in their work. The most famous among them would be a figure like August Vollmer, who's kind of considered the grandfather of American policing. And so when he said militarize or make police more like the military, he meant standardizing procedures, he meant adopting rigorous chain of command, stuff like that, intensifying training. And a key aspect of intensifying training was marksmanship training. So the military experience of marksmanship training filtered into policing throughout the 20th century. And it came to be that the leaders of the policing profession in the middle of the 20th century, who I look at in my book, who become this kind of globe-trotting cohort of experts, they're really into marksmanship training. They go into shooting competitions, and they often kind of trade stories with each other about their prowess at shooting. And this translates into both increased domestic training of police in marksmanship, as well as training of foreign police in marksmanship, oftentimes bringing them to the US to attend training facilities. Ultimately, this kind of obsession with marksmanship training and an obsession with guns it really increases the belief among police experts that new types of guns and new types of weapons, the adoption of military style weapons, should become more regularized. And so we see the adoption of military style weapons frequently after wars, all the way going back to World War II. There's the FBI is facilitating the transfer of surplus war materials into the hands of police. This happens again after the war in Vietnam, and certainly is still happening to this day, as we know. And so my point is that many of the leading police experts really have a very strong interest in guns. They collect guns. They are very much interested in firearms training. And so ultimately what that leads me to hypothesize is that we shouldn't think of the police interest in firearms as separate from the civilian or public interest in firearms. In fact, they're deeply intertwined. And if anything, the police interest in firearms in the 20th century really precedes the much more expansive interpretation of the Second Amendment and the activism around gun rights that begins more intensely in the 1970s.
Thanks very much. And so, Professor Ristroff, a question for you, maybe shifting the terrain a little bit from our focus on, or at least our discussion on, public violence. And I want to ask you, some of your scholarship in a forthcoming book talk about violence in the way that the law relies on and fosters, but at the same time seeks to restrain violence. Since you're both a law professor and a political theorist, I wanted to ask about kind of the connection here. How do we think about the state's monopoly on the legitimate use of violence when we have laws like expansive citizen arrest laws or expansive stand your ground laws? Is it still coherent to talk about a state having or being what the entity that has a legitimate use, a monopoly on the legitimate use of force?
Thank you. Yeah, I mean, I wonder whether the United States is organized as a state with sort of public control, a public monopoly on legitimate violence. That phrase, I mean, it comes from Max Weber, and it is even beyond one particular thinker or theorist. It's a very common understanding of what sort of constitutes the modern state, how we define a modern state. It's maybe not necessarily that particular language, but similar language is used by, for example, political scientists and economists who, in sort of tracking what states have been more stable and which ones less so, there's some work that uses the term violence specialists to refer, say, to the military or to police forces. and a similar kind of suggestion that in order for a state to be stable and to operate, the power to do violence, the power to do lawful, legitimate, violence that is recognized and accepted by the public as legitimate, it needs to be concentrated in public officials. And I know that I think some Second Amendment scholars or commentators have questioned whether, given the Second Amendment, whether the United States is organized on that model. So I think that, you could plausibly say that there in the Bill of Rights is kind of a rejection of that model. I don't know that it's conclusive. You mentioned citizens' arrests, or maybe our stand your ground laws. I think there is a way in which you could look at various parts of American law that do seem to recognize private acts of violence as legitimate. There's a way that you could look at them and try to reconcile them with the idea that the state has a monopoly of legitimate violence by saying, these are sort of very isolated exceptions where individuals are permitted to use violence in the same circumstances that public officials would be able to. If a police officer were there and could use violence to defend you, and then the police officer just isn't there in time, okay, well, you can use violence to defend yourself. So there is, I think, an argument that some degree of acts, some degree of acts of private violence are nonetheless compatible with this understanding of the modern state, because the private violence is sufficiently contained, it's sufficiently regulated, and sort of kept to circumstances where a public official would have the power to use violence if they were there in that moment. I don't know if that account is persuasive with respect to where we are in the United States right now, because I do think there's a kind of strong strand of argument among many who celebrate private citizens' use of force, that the private right to do violence in the United States is, at least some of the time, a right to do violence against the state itself, a kind of resistance. You think about, say the armed protesters at state capitals resisting or protesting mask orders or lockdowns. Yes, I think maybe we can sort of talk about, whether there would be paths to restore or create a monopoly of legitimate violence in the United States. Might be something we could try to achieve, but I'm not sure that it is something that that we have right at this moment.
Thanks. And so that kind of brings us full circle back to Professor Miller. Kind of you point at the beginning of this distinction between private and public violence. And I want to ask, one thing it's hard to ignore in looking at recent shootings where there was private violence, including Ahmaud Arbery and the shooting in Kenosha. They were done by either former or aspiring law enforcement. Does that confirm that there's this law enforcement style of violence that's going to be privatized if the role of police is minimized or limited? Or does the fact that in both of these instances the shooter was arrested and charged, as opposed to law enforcement officers who've been involved in some violence, does that suggest that the law, at least as it stands right now with qualified immunity and the like, is better able to respond to shootings perpetrated by private citizens? In other words, is the outlook better when it's private violence than public violence? Because contrary to what we might think, we maybe have better accountability mechanisms over private violence.
I think I'll take the question in sort of two parts. There's the there's the sort of accountability mechanisms that are imperiled, I think, by the scenario with Ahmaud Arbery, and in some extent also the Rittenhouse case in Kenosha. And then there's also the what do we do about it, and what is the best sort of social policy intervention? Is it sort of criminal prosecution or not? So let me take the first point. Drawing on the remarks that I made before, one of the issues here that must be understood is like the idea that private citizens, and especially private white citizens, would have some sort of presumptive authority to police communities of color draws upon a very deep and poisoned well in American history. So when the Ku Klux Klan is prosecuted in the late 1800s for going night riding, they assert self-defense rights. They say that what they're doing is simply engaging in an ancient function of community policing. When Carl Schurz goes to the South right after the Civil War, he says the last thing you want to do is not have a centralized, professionalized police department, because if you allow the sort of spontaneous community policing to go on, you are essentially going to be consigning the Black population of the South to a permanent martial law where every white is empowered to police every Black person there. So when we're talking about this, we are dealing with a really fraught, racially charged subject. And I think one of the concerns is, about the mechanisms is some of that has been ameliorated in the modern democracy, because you have, Black mayors, you have Black police captains, you have requirements about integrating police departments, and so and when they misbehave, they can be called to account by the political branches. Nobody controls a self-appointed community policeman. When they behave badly, they can't be forced to wear cameras. And this goes to the second part, which is, yes, you can certainly prosecute somebody like in the Arbery case, but that doesn't solve the problem. That might resolve it, but that doesn't prevent it. And to the extent that what you really want to do is try to have policing as an activity be more equitable and prevent the violence, then the structures of, for example, rehabilitating police departments through injunctive relief and things just aren't available in those kind of scenarios. So my sense is that the criminal prosecution portion is, a day late and a dollar short because the violence has already occurred. What you want to do is try to prevent the violence.
Great, thank you. And Professor Chavis, just to carry forward this idea of accountability, I'm wondering how you think the ubiquity of firearms, privately owned firearms in the United States, how does that influence, if at all, both policing, so strategies and tactics, and the way that courts respond to policing through doctrines like qualified immunity? Interested in if you think there is an effect there, and then also what that might mean for reform. So you hinted earlier about some other ways besides transparency, but how does the ubiquity of firearms affect policing, court strategies, and maybe ways for reform?
Right. So I think there are a couple of different questions there, and I take them separately. First of all, when we think about the doctrine of qualified immunity, and Professor Miller has talked, a little bit about that, but this is a judicially created doctrine. The underlying rationale is that you don't want to overly chill the impact of what police officers, government officials, in this case, police officers, what they're doing in the field. So the doctrine acts as a shield to protect them from suit where there is, and this is what's important, where there is a clearly established right. And it can be very difficult for a police officer in the field to figure out whether they are violating well, it shouldn't be difficult to figure out whether you're violating a clearly established right, but we've seen lots of really kind of perverse instances in the case law. I personally, and so we hear a lot now about, oh, we should, truncate this doctrine of qualified immunity. I think that that there is some merit to that, but whether I think it's going to be a particularly good reform to actually impact police accountability, I'm not sure. It's still what I call a backward-looking reform. You can only have this after you get qualified immunity, only after the behavior has occurred, only after a police officer has shot or killed, injured someone. And so I think that we need to be, while we can focus on that, and there's room there, I think that our reforms should be more forward-looking and thinking about how do we actually prevent the violence in the first place. And it's just not, I don't think that there's a clear enough nexus there, or at least we need, more research on this to think about whether or not that qualified immunity or lifting qualified immunity would have us have more police accountability, or more successful suits, less deaths, right? That's what I think what we all want is, less deaths at the hands of the police, less unjustifiable deaths. So I'm not sure that's related to the ubiquitousness of firearms. We do have a tradition in our country that goes back to the founding about having firearms. But what we also know is that treatment, we've seen some disparate treatment as it's applied when race comes into account. And so I can give anecdotal accounts of what, Kyle Rittenhouse walking down the street with a long gun and receiving praise from officers, and then Philando Castile, or at least in Kenosha, Jacob Blake not having a visible weapon at all, and the fate that he met. I also think when we think about training, law enforcement officers are trained in states where I know, for example, in North Carolina, if you have, concealed carry, officers are trained with how to approach any citizen that could be carrying a firearm. This is, it is very much a part of our country and what police officers know. It's just that, quite frankly, different races seem to be treated differently. Philando Castile, there was nothing more, and this is in Minnesota again, I'm sorry, there's so many cases that they tend to bleed together, but with Philando Castile, there's nothing else that he could have done to tell that officer, yes, I'm legally allowed to carry it, I do have it, before the officer, shot him to death in front of his kids, so in front of his child. So I think that we really have to have a reckoning with, yes, firearms do play a part in officers and how they react, but there's something more there. There's something, yet we know that it's different when you happen to be a Black male versus a white male. And we can go on with the different examples of Dylan Ruth being taken. He shot 9 people at Mother Emanuel Church in South Carolina, and he was taken alive, and yet we have so many people that are killed. It's almost a shoot first, ask questions later when we have a racial minority involved. So there's some stereotyping and things that are happening.
Great, thanks. And turning to you, Professor Schrader, and maybe kind of, again, abstracting from this point of training and background and context and experiences of police forces and law enforcement, your book forces us to think about how the role and the firepower of U.S. police forces were really shaped by the perceived need to respond to military and civilian counterinsurgencies, sort of an intertwining of domestic and foreign policy, maybe encapsulated by the Office of Public Safety. But maybe there's also a story about the relationship between public, a state-sponsored state, and private, like corporate or individual forces. You know, OPS shut down in 1974. Is there a similar organization group? Are there private actors who are fulfilling that role today?
Yeah, absolutely. So the book, as you said, it focuses on the Office of Public Safety, which was the overseas police assistance and training arm of the U.S. government, which operated, at the height of the Cold War and was shut down by Congress in 1974, 1975 amid accusations of human rights violations. In my work, as well as the work of Nicole Siegel from Indiana University, what becomes clear is that the private security sector really dramatically begins to expand in the middle of the 1970s, and that private security sector is really at the intersection of foreign and domestic policy. And when the Office of Public Safety closed, a number of its advisors, police advisors who were stationed overseas, they basically keep doing the work that they're doing by founding private companies or going to work for private companies. And, as an example, there's a company called Vanel Arabia that is operating to this day in Saudi Arabia, training the National Guard there. This firm got its start with Office of Public Safety advisors who, when Congress shut them down, they basically just stayed on the job in Saudi Arabia. And instead of being US government employees, now they became private employees. And the paychecks they were receiving were probably a lot larger as soon as they became private employees. And the idea was not only to continue this work of training and assisting police overseas, it was also to expand its scope. But in addition, this was a moment in the 1970s of increasing congressional oversight, increasing congressional control over the operations of the US national security state, investigations into the CIA, and so on and so forth. So the Office of Public Safety was closed down, and these private firms emerge to keep doing its work precisely outside the oversight and accountability mechanisms of Congress. And this private security sector, of course, has just dramatically grown in the decades since the 1970s, and it remains largely outside the control of Congress, even as it is fully dependent on the federal government for its revenue streams. And because it's outside the control of Congress, because the Freedom of Information Act doesn't apply to private security firms, it's very hard to know exactly how they work, how they operate. For me, writing my book about the Office of Public Safety, I was able to use public records that anybody can look at in the National Archives. If I were to try to follow the story forward past the middle of the 1970s, because of course the story does continue, it becomes much more difficult simply because these private firms are at the center and they don't make their archives available to researchers most frequently.
Great, thanks. And Professor Ristroff, to kind of return to a theme that we spoke about earlier, some theorists like Malcolm Thornburn have analyzed the private use of violence as stemming from a delegation of authority from some higher level of political organization like the state. So maybe we might think that the state's monopoly of violence still holds if it's authorizing private violence. And I'm wondering kind of what are your thoughts of this theory with respect to your own understanding of a political theory of violence?
So I think that question, kind of pulls together or returns to the sort of line we've been drawing between public violence and private violence, acts, use of weapons, shootings, or other acts of physical force by government officials versus acts of physical violence by private officials. And without disputing the importance of sort of careful thinking about whether violence is coming from a government official or from a private individual, I would say I think that there are kind of two other inquiries about violence that are really important to the conversation, and important especially to thinking about the moment this country is in right now, with frightening levels of violence and patterns of racialized violence, which are not unique to this moment, but I think are capturing public attention perhaps more than usual at this moment. So the two other things, so one question you might ask about acts of violence is a sort of public-private question. Is it a government official who might be subject to mechanisms of accountability that Daryl, that Professor Miller was talking about earlier, or is it a private individual using violence? There's public-private, but then I think there's also important questions about, first of all, just the total amount of violence. How much overall are people shooting at each other or exercising physical force against one another? I think that's an important consideration. And then there are questions about the distribution of violence, and not just the distribution of violence. You're thinking this in two ways: who's on the receiving end? Are acts of force sort of spread around equally so that the targets are evenly distributed across different racial groups or across different segments of society? You can also think of the distribution of violence in terms of the distribution of the power to do violence. Is it something that's concentrated only in public officials or only in a few private individuals, or is it something that is widely dispersed? So I think those questions, the total amount and the distribution, are really important to add into the conversation here. I think there's an argument that, since we were talking about this idea of the state having a monopoly on legitimate violence, there's an argument, not necessarily one that I am convinced by, but there's an argument that by breaking up the state's monopoly on legitimate violence, by having armed citizens, for example, you are going to reduce the overall amount of violence, that you're going to have a less oppressive state. I mean, I think this is, one defense, one argument in favor of the Second Amendment is you're going to have a less oppressive state. You're going to have a state and public officials who use less violence overall if they know they don't have a monopoly on it. There's also, I think, a distributive argument that, again, if the state doesn't have a monopoly on violence, then the power to do violence and the risk of suffering violence are going to be distributed in a more egalitarian way rather than concentrated. I think that the reality in the United States has been very, very different, that having protections for private, legal protections for private acts of violence has radically increased the overall amount of violence, and it's also played out in certain distributive patterns that Professor Chavis was mentioning earlier. I mean, there's definitely a racial dynamic to the kinds of arms bearing that are most recognized, are most endorsed by law, and those that are seen as criminal. I mean, I just have to say, I just came here to the webinar from teaching criminal procedure and thinking about the Fourth Amendment's attitudes toward public and private violence. the Fourth Amendment sees our constitutional doctrine in addressing the powers of police officers. It sees the presence of guns in private hands as a grounds for expanding the public authority to use violence, for grounds for expanding police power. The police are sort of authorized to do many things because the person that they interact with might have a gun, might be prepared to injure them. And so I think, you know, you can sort of dig into particular areas of doctrine and really see how much in this country here, the decision to kind of disperse violence or just, you know, give rights to use violence to private individuals, it hasn't constrained the state's power to do violence. If anything, it's expanded it by generating a law that gives police officers greater powers than they might have if we didn't have an armed citizenry.
Thank you. That reminds me of kind of the debates about whether, for purposes of a stop, if someone's armed and dangerous, or if they're armed and therefore dangerous, and the debates that we're having as more and more public carry becomes more and more widespread about how that might be changing some constitutional doctrines. So I want to leave some time if there are audience questions. So if you have questions, feel free to pop them into the Q&A chat now. I've got a couple more, and we'll be monitoring the Q&A chat if you do have questions. So Professor Miller, one more for you while we're seeing if we have other ones coming in through the chat here. You argued in a recent Washington Post op-ed this week that we shouldn't allow armed groups like militias, private militias at least, to become normalized. And I'm wondering, how can we prevent that? Is it legal rules prohibiting armed assembly? Is it counter protests? Who has the standing to challenge or change or defend those relevant norms?
Right. I mean, that's a really, really difficult question and a really good one. And I suppose that it's a combination of all those things, right? We have a difficult time sort of figuring out the directional arrow of you know, norms to laws and laws to norms, and laws have a way of sort of affecting norms and vice versa. My sense is that you know, it needs to be seen as an aberration just among people's sense of rectitude to be showing up to political rallies with firearms. I mean, that would help sort of reduce the tension. That's why, for example, you know, the appeals to peaceful protest, Martin Luther King, is so important, because to the extent that he is seen as the model of how to go about doing profound social change without the threat of violence, to the extent that he's the hero of that kind of political dynamism, we need to recapture that as a matter of our sort of political discourse and our norms. Now, that doesn't mean that there isn't a role for law as well, you know, to the extent that laws can say, you know, public carry, you know, in big groups needs to be licensed, or it needs to be checked out ahead of time, or you need to have a permit or something like that. That would help prevent what could be a really dangerous cascade of, oh, well, I know that this group is going to show up in the public square with guns, and therefore I'm going to show up with guns as well. And that's a cycle that we don't want to get into. I just want to mention really briefly, I think something that Professor Ristroff was saying that I think connects with Professor Schrader, which is I think it's an astute observation, that the fact that we have a proliferation of guns in private hands tends to escalate the justifications for use of violence by state actors. And as Professor Schrader probably notes, it knows that goes not only for like Fourth Amendment stops and frisks and other kinds of violence, but probably even the equipment that people have. That is, if I am a police officer and I know that the people that I need to investigate for crimes might be armed with weapons that can penetrate body armor, that is going to lead me to want to have some kind of protection that will escalate. And what we don't want is some kind of arms race between, private weaponry and public weaponry.
Thanks. And so, Professor Chavis, let me ask you, you've recently written about kind of critiquing stand your ground laws. And I'm just wondering if you could say a little bit about why these laws, which are written in race neutral terms, why are they a special risk to Black lives?
Yeah. So when we think about, stand your ground laws, and this is like, first year criminal law, where we've talked about self-defense, and usually under the common law, there's a, duty to retreat. And so what these laws do is they allow you to use, when faced with danger, allow you to use deadly force without retreating. And what we've seen, is, and we can look at like the case of Ahmaud Arbery, it really kind of gives an excuse for, it can give an excuse for vigilantes to act on their own biases. Well, what makes you think someone was dangerous, or why did you feel threatened in that way? And even though we know that it was not a defense in the Ahmaud Arbery case, I do believe there was a slight delay because it allowed the authorities to begin thinking, okay, could this have been? So even though these laws are written in race neutral terms, we should be, I think I'm a very big proponent of thinking about any types of legislation when we think about it in the criminal justice space. What is the racial impact of that law? And I think there are some questions we need to answer. Stand your ground laws, and again, backed by the gun lobby and nearly 31 states, something like that, have these laws. It's meant to protect yourself from some type of violence, but I think what we're finding is that it actually escalates violence, and people, because they don't have the need to de-escalate. So that's something to think about. But I think that we need further study because there are some conflicting, dueling studies on whether or not these laws are actually whether or not they impact Blacks differently than whites. And so I think one good question to ask is if we did justifiable homicide by Black defenders increase, remain the same, or decrease after the enactment of some of these stand your ground laws. And so there have been some studies on that, but there's conflicting evidence. I just think that in the moment that we're in and what we're seeing play out on our city streets, we have lots of folks who are, say they want to, defend their right to be there. And it really gives an excuse to escalate violence rather than de-escalate violence and promote the sanctity of human life.
Thanks. And let me go to one of our questions then, and it's for the panel in general. And it says, I realize there's no silver bullet, but if you could have one reform to address this complex problem, what would have the biggest effect? And if I could add an addendum, do you think the best level of government to respond is state, local, or federal, or the best level of government to seek reforms? And so I'll open that up to the panel if someone wants to hop in on that.
Well, I'll hop in just on, there are lots of different levers that we could pull at the federal, state, and local. The federal government actually has the ability the Attorney General, United States Attorney General, has the ability to seek injunctive relief in cities that are showing, police departments that are showing a pattern or practice of unconstitutional violations. That is only one authority, and they have limited resources. But what I was going back to what I was saying earlier is that they actually have the ability to change the culture, to enact policies that would change the culture inside the police department that would, in theory, prevent more of these deaths. And that the reform is really wide-reaching in terms of the transparency that I was talking about in record keeping, but also changing your use of force standards, which is something we have to do. We're not going to solve the issues unless we really take a look at the use of force. But where I think the strongest lever is in my opinion, it is absolutely at the local level. The local levels, and we've seen this in recent months, have the ability to move very quickly with reforms within their police departments in terms of that use of force standard and how or whether a particular officer is going to be prosecuted, and different changes that they can make. So I think that our local communities here have the power, and that while the federal government should be there as a backstop and has really good, there's some really good resources and things that we can do, I think our local communities can and have to act.
So I think I would agree with everything that Professor Chavez has said. I'm working with my former law school classmate and friend, Professor Fagundes, on a piece about cities and guns and the city's rights about guns, decisional autonomy. And I think it applies to both policing and guns. That is, to the extent that you have a representative body in a city who says, this is the kind of policing that we want to have for our own community, and to the extent that they also have some kind of decisional autonomy to prevent people from outside the community coming in and saying, oh, well, since you don't have a police department, or a police department that we think is the one that we would like, we are going to privately decide to police you. I think I think that devolving those kinds of decisions to the actual city would make sense. Now, this is not going to go in one direction. You might end up with cities that just like guns a lot, but to the extent that they are territorially bounded and don't have the same kind of spillovers as other kinds of arrangements, then people that want a certain type of policing, a certain type of gun culture, will go to those places, and people that want another kind of policing and another kind of gun cultures will go elsewhere within certain constitutional parameters that everybody here sort of understands. But I think that makes a lot of sense to me.
Great. So let me go to one more question here. I think it'll probably be our last question. And this one is for Professor Schur or anybody else on the panel. And it says, another way that police might, even if inadvertently, encourage a kind of domestic militarization is by encouraging private citizens to think of themselves as law enforcement officers and to bring powerful weapons to scenes of perceived lawlessness. Even as a teenager, Kyle Rittenhouse found ways to be involved with local law enforcement, even including through a cadet program. Any idea how widespread these programs are, and how can or should police build links to communities without encouraging armed vigilantism?
Yeah, that's a good question, and it's not something that I've specifically looked at, but I just to pick up on what Professor Miller was saying earlier, I think it's absolutely true that we are living through an arms race between private actors and police, and there's just no question for me that this arms race needs to be ended. How that happens, of course, is a very complicated and challenging question. To the extent that police are encouraging the types of behaviors that we're seeing among people who self-style themselves as militias, this is really worrisome and frightening. And I think that many people who are suddenly realizing that this is happening after the Kyle Rittenhouse's shooting, should be encouraged to note that this has been happening for some time. This did not just emerge in the past couple of years. There's a long history to this. Of course, in many ways it goes back centuries, but at the very least, I do think we can look to the radicalization of white power activists since the 1970s and 80s. And there is a direct influence of military models, military behaviors, military styles of dress. I mean, Rittenhouse himself was really dressed as if he were a special operations soldier overseas. I think that's very conscious. So the context for this is something that I think we can talk about and identify and in fact locate both within police departments, but also beyond police departments. Ultimately, these questions cannot be answered solely by addressing policing. They're, of course, as everybody on this panel has suggested, they're questions that require a much broader social, political, and legal, conversation.
Anyone else have thoughts on kind of that particular tension with police trying to build ties to the community without kind of encouraging mimic what we do and go police your own neighborhoods with powerful weapons? Anyone else have thoughts on that particular question, or any other kind of final parting thoughts?
Could I just throw one thing out? This question about, sort of state officials kind of cultivating assistants, informal deputies among private actors. As Professor Schrader said, I mean, it has a long history. It's not a novel development. One piece of the history that just popped into my mind when Professor Schrader was speaking just now was the practice of slave patrols, which has got, I think a sort of a bit more attention in recent months, and sort of drawing the connection of that to modern policing. I think one historical aspect of that practice that's interesting and important to this discussion we're having right now about private individuals is that many individuals who were sort of conscripted or are asked to serve in slave patrols were poor whites who did not themselves own slaves, but they were, sort of asked to participate in this patrolling function to watch for runaways, to make sure that slaves did not arm themselves. But the people who were asked to do it were not themselves necessarily slave owners. And I think, folks have written about that dynamic as a way in which sort of asking impoverished whites, or at least whites who are too poor to own slaves themselves, asking them to sort of participate in managing the slave population was a way of not just preserving slavery or maintaining slavery, but was a way of managing class conflict, or trying to, prevent class objections from the poor whites who didn't enjoy all the material benefits of slavery. And so I do think that, when we sort of think of government officials sort of embracing private actors' use of violence, or saying, help us out in this way. I think it's worth pursuing class dynamics as well, and seeing, is this a way of managing class tensions and sort of using aggravating racial tensions to deflect away from potential class tensions.
Okay, well, that is a good, if sad, note to end us on today. So thank you to all of the panelists for being here for this really important discussion. Thanks to all of you for joining us at home or wherever you are. Special thanks to Teresa Boyce and Isabel Fox for helping out behind the scenes, and everyone else who helped out making this event possible. Thanks for joining us. Feel free to reach out if you have any questions. You can email the center and visit the center's website and follow us on Twitter for more commentary on Guns in America. Thanks very much.
Thank you. Thanks, everyone.